So this is another situation where, in this case, the default is no access to the newly adult person's records because they are an adult, and that means everything in the record, not just the sensitive data that they may have been able to consent to as a minor. They have their own consent rights. They can seek their own treatment, even if that care is continuing to be paid for by the parent through parental insurance. They are still an independent adult individual with full autonomy to make decisions, except in a circumstance where the child is actually not able to make their own decisions. They have a disability of some sort. Maybe it's an intellectual disability. Maybe it's a developmental disability. Maybe it's a combination of a lot of disabilities where the child is unable to form the requisite intent to consent to medical treatment. And that's the threshold. The threshold is about, are you capable of consenting to your own medical treatment? And if you are, then the privacy rights go right along with that. But if you can't consent to your own treatment and you're a parent of a child that doesn't make their own medical decisions, you've actually got to get some sort of authorization from your state to be able to continue to make medical decisions for your child. And once you have that authorization, the privacy rights come right along with it. You'll be able to access the data because you're essentially the medical decision maker for that, for your child, who is no longer a child, is an adult in the eyes of the law. But the law also recognizes that some adults can't make decisions for themselves. We actually have a number of patients on our platform who have rare disorders that occur in childhood, where the symptoms begin during childhood, and where you're talking about children who have never made medical decisions for themselves and still are not able to do so as adults. But when you're in the role of a parent, there's a default assumption that the parent, except in those, circumstances with the types of care that I'm talking about, that the parent makes the medical decisions for the child. Once that child hits 18, then legally they're an adult until you take the steps that you need to take to get the legal authority to make medical decisions for them. And that's a power of healthcare attorney. How you do that kind of varies a little bit by state. I think sometimes you can online find legal forms, and for a very small fee, you can download them, fill them out, sign them, and get them notarized, and that's sufficient. There might be additional process required in other states. It's one of those situations where it can be very helpful for you to be like in a social community or working with an advocacy group that has the same disorder as your child, so that you can talk to other parents that have been through this, that live in your area. What did you do? Sometimes that your doctor or your hospital may actually have a social worker that actually knows exactly what you need to do in terms of the paperwork and the forms. And then you'll need to keep that paperwork because that's your ticket to fighting back and getting access to your child's data when they cut you off immediately.